Okay, welcome back for our second panel of the afternoon, Space Operations and Russia's War in Ukraine, Questions of Neutrality, Space Support, and National Commercial Cooperation. To moderate this panel, we have Major Danny Beaulieu, the Chief of Operations Law for Space Training and Readiness Command, or STARCOM. This field command builds and leads the U.S. Space Force's education, training, doctrine, range, aggressor, and test programs. Major Beaulieu also serves as a space law instructor at the National Security Space Institute and the 319th Combat Training Squadron. Major Beaulieu received his LLM in Air and Space Law from the University of Mississippi School of Law. Over to you.
Good afternoon, everyone. It's a pleasure to be here. I am really excited to be joined by these three distinguished panelists whose bios you have, and to be discussing this important and timely topic with respect to the Russian war and neutrality and issues of government and commercial cooperation. I'm going to introduce each of the panelists very briefly and then let them present. And after each of them have presented, we'll open up for questions. First up, we're going to have Professor David Burbach. He is an associate professor for national security affairs at the U.S. Naval War College. He teaches politics of U.S. foreign policy, space security, and international relations. Next, we have Mr. Chris Shank. He is the vice president for defense and space programs at Maxar Technologies. And over the past 30 years, he has held various roles in the military, U.S. government, and commercial industry. And finally, we have Professor Hitoshi Nasu, who is a professor of law at the U.S. Military Academy at West Point. Professor Nasu publishes widely in the field of public international law, with particular focus in international security law, the law of armed conflict, and the law of weaponry. So with that, we're going to go ahead and get started. Please, Professor Burbach, it's up to you.
Thank you. Good afternoon, everyone. And I appreciate the opportunity to come here and speak to you today. Before I begin, let me start with the standard DoD disclaimer that I'm here representing my own views only, not those of the Navy or the Navy War College. I'll add a second disclaimer that I'm not a lawyer. I am married to a lawyer, though, so I have learned that I should definitely stay away from opining about legal matters. So my intent today is not to try and tell you about what space law is or should be, but to talk about some trends and situations that space law is probably going to relate to, things that you're going to have to deal with. And specifically, I'd like to talk about commercial space and its relation to international conflicts, with a particular emphasis on some examples of what we've seen happening with Ukraine. So I promise I will not be doing the usual DoD thing of having a million slides. After this one, I've mostly just got a couple of images to illustrate some points. But I'll start out with a bit about what's changing with commercial space. Talk about some of how we've seen commercial space being used for military applications in Ukraine, some future trends that we might expect, and then the questions that you're going to probably have to wrestle with and think about what space law says on these issues and how we're going to deal with it. So what's been changing in the commercial sector? Well, quite a bit, actually. The image you see on your right is one of the founders of the Planet Labs imaging company. I hope Chris doesn't mind me touting a competitor here.
Hey, I used to work with Will at NASA, actually.
Excellent, excellent. What he's holding is not a model, though. That is an actual size satellite, one of their Dove imaging satellites, of which they intend to have hundreds in orbit. The commercial sector, commercial space has been around a very long time, of course, but we're seeing it become a little less like manufacturing a stealth bomber and a little more like manufacturing an iPhone, in that electronics have become small enough and they're able to use sufficiently off-the-shelf components to operate assembly lines and really do very capable things with very small satellites, and be able to provide militarily useful information from relatively affordable commercial products. One of the things that also feeds into, the chart that I have there on the other side, shows the number of satellites operating, and that's actually, but this is now a chart that you need to update on a monthly basis almost, where SpaceX alone has launched 4,000 Starlink satellites. There are probably more than 5,000 active commercial satellites these days, and probably are headed towards tens of thousands, where with satellites able to be now so small and so lightweight, combined with the reduction in launch costs through new launch technologies from SpaceX and other companies, that companies can now put up thousands of satellites. And what that means is they're able to provide nearly continuous coverage. Starlink is able to provide global communications capabilities from low Earth orbit, which allows them to use more power and have less latency and higher speeds. For imaging, they're able to have constellations with sufficient numbers to have very low revisit times and provide timely imaging all over the Earth. So we're seeing quite a few changes. And then I don't have a cool image for big data. I wasn't sure whether to bring a server farm or some kind of weird cloud. But it is important that the changes are not only happening in space. The change in the commercial space sector very much also relies upon data analysis, being able to take the gigantic quantities of data coming from all of these satellites and do something useful to it. If I were able to give you a high-resolution image of the entire globe every hour, you would be drowning in all that information. You wouldn't know what to do with it. So in order to really make useful all of this revolution in the space sector, we also, the data sector being able to do analysis, storage, transmission is also extremely important. One implication there is that important players in the commercial space sector may not be in space at all. And may operate entirely on the ground. I know Maxar certainly does analysis as much as they do imaging, but there are going to be players not only putting things in space, but operating systems on the ground that make useful observations out of what we see in space. So that's the general pattern of what's changing. What this means, it's got a couple of implications. Even for the United States, the commercial sector is becoming good at things that we aren't necessarily as good at on the governmental side. And beyond the United States, beyond traditional space powers, this opens up the possibility for countries with no real indigenous space capabilities to purchase meaningful military space capabilities. And that's what I think we've seen in Ukraine. You may be familiar with some of the examples here. So, let me go through some of the basics. Most dramatically and most famously, Ukraine has made use of the Starlink communication system from SpaceX. You can see the image there shows a Starlink team. You can power it with this kind of solar panel you might take camping, a 12-volt car battery, and then that tiny little flat antenna. And they're able to provide pretty high bandwidth communication, as much as 10 to 100 times some of the traditional satellite communications platforms, while also having pretty good security because that's a phased array antenna tracking the satellites actively. It's a relatively narrow beam and thus a little harder to intercept. And this has been really important for Ukraine. Even before they switched to Starlink, were forced to switch to Starlink, as I'll talk about in a minute, they had integrated Viasat technology and really tried to rely on a very decentralized command and control system. Most famously for fires, they use a system called GIS ARTA. Some people have called it Uber for artillery, where at a relatively low tactical level, people collecting intelligence, collecting observations of where enemy forces are, can input that into a system. Individual fire teams can then, like an Uber driver, say, we can hit that, we can do that mission. So rather than pulling it all up to a high-level fire direction center that then sends out missions, it's very decentralized, but that requires a lot of information to be moved around at low tactical levels, and Starlink has given them the ability to do that. Imaging has also been extremely important for Ukraine. Ukraine does, I believe they do have before the war had one satellite of their own, but really they've been able to rely heavily on commercial imaging. That's a Planet Labs image showing the airplane still on fire at Kherson Airport after a Ukrainian strike. So you could do bomb damage assessment from that commercial image. And particularly important, probably on the left, radar imaging. Synthetic aperture radar, which is able to operate at night and through clouds, has been very valuable to be able to, for example, in that image showing the Russian columns assembling on the first night of the war, but being able to, with in a very timely way, provide useful information even in conditions that make traditional optical observations impossible. And we know Ukraine's not the only side of the war that's been getting that kind of commercial imagery. We recently imposed sanctions on a Chinese company that's accused of selling synthetic aperture radar data to the Russian Wagner Group. And in fact, it may be surprising, why would Russia need commercial imagery? Russia's actually fallen pretty far behind in their space ISR, and it actually isn't at all surprising that Russia and certainly Russian commercial mercenary firms have felt the need to buy some space images. There's a little less known about this, but there are also now commercial, not SIGINT, not intercepting and listening into communications, but ELINT or electronic intelligence firms providing information on radio sources. The map you see of Asia there is from a company called Hawkeye 360 that has a constellation that triangulates radio frequency sources. They provide maps of GPS interference. The map there shows over time a collection of RF emitters in various sources, or even people are able to exploit civil open source data. The image showing the Baltics there is from the European Space Agency's own synthetic aperture radar satellites. Clever hobbyists discovered that if you find the right interference patterns within that radar image, it actually identifies air surveillance radars. And so there are hobbyists identifying, you can find Patriot sites with it very easily. Hobbyists identifying there's a radar here, even hobbyists who have been tracking, hey, it looks like one of the Russian ships turned on their search radar in the Black Sea. I would have to assume that Ukraine is clever enough to be making use of that kind of data, though we've seen less reporting on that. And then beyond the use of this space data, what have we seen in the way of counterspace activities in the war against these commercial operators? Well, we know the war began with a Russian hack against the communications company Viasat, where they were able to infect the firmware, the embedded chips in Viasat receivers, and disable them, not only for Ukraine, but for many European receivers, thus the switch to Starlink. They've apparently been attacking Starlink as well. So far, SpaceX has been able to stay ahead of Russian cyber attacks to keep the system operating. We know that Russia has indicated they consider commercial satellites and commercial operators to be legitimate military targets. They've been very clear that they think SpaceX is Starlink's a legitimate target. At one point, the head of the Russian Space Agency, Dmitry Rogozin, even appeared to threaten Elon Musk personally. They haven't carried that through in any way, but they've been very clear that they would consider that a commercial target. Or on our side, well, we certainly haven't done any physical attacks on capabilities that would help Russia. So I mentioned we did impose sanctions on a Chinese company that's been selling information to Russia. So, there has been some attempt to try and take away some of these space capabilities too. Before I get to questions to consider, just, in terms of future trends, we're going to see more of this. Many of you probably know the U.S. has said we want to make much more use of commercial imagery. Commercial imagery, commercial communications. The United States, are going to be buying much more of this and forming much closer partnerships with more commercial providers. We're also, as in the case of Ukraine, likely to see more and more belligerents on their own purchasing space capabilities. The Ukraine likely is going to serve as a model for other countries in the same way that we've seen drones proliferate. Drones became very important in the Armenian-Azerbaijan conflict recently. Ethiopia has been using them in their civil war jointly with an Eritrea involved in that as well. In the same way that this technology has become available to relatively lower technology combatants, we're going to see countries like that wanting to purchase space-based military information as well. And that's only going to increase the interest in counter-space activities. China, for example, just a couple of weeks ago, said that they plan to launch a constellation of 13,000 satellites that would duplicate Starlink's function, but would also, and they weren't really clear on what this meant, would be able to disable or counter Starlink. Now, it's not clear if they want their satellites to shadow. It may just have been empty rhetoric, But the Chinese in several instances have made it clear, like the Russians, they too consider the commercial sector to be a legitimate target. So what are some questions that we might want to consider on, on the larger legal and policy side? I'm sure Chris can tell us much more about this, but the commercial sector, I would think, wants to know, what's the US government going to do for us? How are they going to protect us? Whether that means, actively shoot down incoming anti-satellite weapons, threaten to retaliate, extend deterrence to commercial operators, help commercial operators fight back cyber attacks or other attacks on ground segments. And especially, what if the commercial operator is not helping the US government, but helping Ukraine or helping Armenia or Azerbaijan? Or what are we willing to extend to companies that are providing military relevant services from space where we're not a belligerent? And as my second question implies, what about the interesting question of private actors making their own decisions about who they want to help? We've seen in the case of Starlink and Elon Musk, Musk has been pretty actively tweeting his concerns that the conflict's going to become World War III. Already, SpaceX does not let Ukraine use Starlink signals over Crimea. They don't want Ukraine to use it for active drone control and navigation. They're making policy decisions about what are legitimate military targets for Ukraine or not. I would assume that that's consistent with US policy. I don't know what kind of private conversations happen, but this question of what limits, or if tomorrow Elon Musk said SpaceX is out, we won't help Ukraine anymore, is there anything the US government could do to try and, formally or informally reverse that decision? And then finally, what about commercial operators in other countries? We already have this example of sanctioning a Chinese provider. If, for example, an Indian or UAE or Israeli company were selling imagery to a country that was a belligerent that we were opposed, would we sanction them? Where would be the point that we would take an actual kinetic attack against a third-party commercial satellite or cyber attacks against them? So I think a number of questions that we're going to have to face, not only about our own commercial sector, where we fortunately have a real lead, but as we see relevant technology levels rise in other spacefaring countries too, we're going to have to think about what we are willing to do to counter third-party neutral commercial firms that may be contributing to the military activities of adversary countries. And let me stop there.
Thank you. Please, Mr. Shank, please go ahead.
David set things up really well, set the table for us. Pursuant to what David said about not being a lawyer, neither am I. I'm an aerospace engineer, but when I worked for 10 years in the House of Representatives for the Science Space Technology Committee. So one time I was working on a piece of legislation, and a group of university lobbyists asked me, like, so what's the Senate reaction to your bill, Ben? And I said, I married a Senate staffer. I know what it's like to be condescended to. So she is a lawyer. So we both married up. There you go. And revising and extending my remarks, on that. I'm going to back up a little bit and tell just some war stories on this. I apologize for not presenting some charts, but with Maxar imagery, if you have a CAC card, you can go online and go globalegd.com, g-egd.com. Login, and it's a service that we provide through the National Geospatial Intelligence Agency. We have over 400,000 users of that, and all it requires is a CAC card or an email out to NGA and saying, "Hey, I'd like to get Maxar imagery." But it's not just that. To what David alluded to, there's a lot of other commercial providers out there, and so we also, through that same portal, provide planet imagery, black sky imagery, as well as synthetic aperture radar is also on that same platform. So that's part of where we are viewing ourselves as a integrator for commercial sources, various commercial sources, and that includes working deals with other companies, as was announced recently. Our business deal with the Umbra, space company for their synthetic aperture radar, which is some of the most highest resolution, out there today in the commercial sector. unlike that was Will Marshall that you showed a picture of. I used to work with him at NASA when he was at the Ames Research Center out in Silicon Valley. And he told me about, he was launching iPhones into space. It was like 2010, time frame or so. And then they went, he and his group of Ameriband went out and founded Planet Labs. Our satellites are qualitatively different. So by the time that Ukraine, well, actually, we have been monitoring the Russians for years. We were there for Crimea. We have 4 currently satellites up on the order of 0.3 of a meter resolution, and with targeting quality capabilities on GPS on the order of a 1.5 meters SCP. In terms of running big data, we have our library is over 20 years old of that kind of monitoring, so that we're able to provide not just 2D, but 3D and 4D resolution of the planet. So that when it came to like the evacuation from Afghanistan, we were able to, around the Kabul airport, we were able to provide one world terrain mapping of around there, so that our forces could figure out how to get citizens out of country. We were there and watching, and we were sanctioned during the 2014 invasion of Crimea. So we purposefully, after establishing 20 years over 20 years of operations, working shoulder to shoulder with the Department of Defense as well as the intelligence community, I thought one of the most telling images that General Dickinson showed, during the video presentation, is people working shoulder to shoulder next to each other in a badgeless environment, international, US DoD, IC, as well as contractors. We do that. So for me, we had watched the setup of Ukraine for months, going into that, starting in November 2021. And it was obvious the intentions. When you have 100,000 troops and that many encampments around the country, I remember vividly that morning. So we have geospatial analysts that work for us and do software development. A guy came to my office at 6:30 in the morning, and he goes, "You need to come downstairs and see this in our skiff." And he goes, "I had set up some machine learning boxes around the encampments that the Russians had around Ukraine. And they all alerted me this morning that they're on the move." He then combined it with synthetic aperture radar data. It was NTM in this case, but we also can do commercial. And it showed convoys were moving out. And then we combined that with electro-optical. And so we're able to see, okay, what kind of armored carrier vehicles, tanks, et cetera, artillery units, et cetera, that they were, on the move, going to invade. It was not a light decision on the part of the Maxar CEO, Dan Jablonski, U.S. Naval Academy grad, 1991, general counsel for Digital Globe beforehand, and currently CEO, because he knew that raising our profile like we did made us a target. To David's point, they already view us as, that under the control of the US government. Now, we all know that the relationship is much different. It's cooperative, it's contracted, et cetera. The other C's of congested, competitive environments. And so we're commercial and we're collaborative. And those are the other C's that I'd like to add to this, of how we work together on this in this environment. And so he knew we were going to be a target, and this is an unclassified environment. Sorry, I can't tell really good war stories. What I will share is in terms of tip of the iceberg kind of things, but it's eye-watering. I mean, what we also did, Maxar did, with missile warning software development. As a commercial company, we are approaching the problems of software development quite differently than say the incumbent folks have, other companies have done. We are approaching it differently. We have saved the government 2 orders of magnitude of money. a story that I love to tell, I can't get into the details of it, but one of our customers working just up the street up at Buckley Space Force Base, went out and said, hey, can you make this software change for missile warning to another company? They said that'll be $1 million. And our guy told them that he would do it over his lunchtime. Okay. Like it's not that. And so whenever people say this is hard, it's really not that hard. Put your mind to it, get to know the system. There's a much better, richer story that we have shared with the joint OPIR group on terms of turning things into operational software that goes into other things. Another thing that Dan Jablonski had shared in terms of showing people that we are going to be in this fight, together, and we're going to be part of the strategic messaging for the U.S. government, independently of the U.S. government. We are not asking for permission, from them, but we have developed over the decades a working level of trust, and trust is important. The machine learning algorithm I was talking about, it's about trust. You have to trust, in that, and you've got to test it. And so thus far, yes, there's been lots of private conversations between 24/7 op centers here in Colorado to our 24/7 op center, up there. But some of the other conversations we have with the Department of State, for example, is the mass graves in Bucha, the strike, the artillery strike against Mariupol with the children in the theater. And our imagery is going to be used in war crimes. That is, everyone said this is going to be part of the case. And so it's worth it to be part. And so we said, Dan Jablonski, very early on when Ukraine started, had an all hands for everybody in Maxar, because everybody's in Zoom now. And he goes, when the history of the Ukraine war is told, I want a Maxar image, on there. And he goes, and I want everybody to know that you're part of this, that you're part of this fight. And so, yeah, we get threatened. Yes, our satellite's been targeted, but we've been able to get through it. And that's a part of the resilience calculus that General Dickinson, also used. And so we do a number of, in addition to that, a number of open access programs whenever there are natural disasters like what happened, recently in the Middle East. For that, again, when it comes to open access programs and opening up our satellite imagery, that's just part of being a good citizen, for that. I do want to end though, because I realize probably rambling on a little bit here. So we were celebrating the 1-year anniversary last week of the Ukrainians, survived and made it through a really difficult year. And so I was in the skiff and I was briefing somebody else and I was like, oh yeah, that's right. It's the 1-year anniversary. And I was briefing somebody and I went back to go find that guy who had, set up, had to, found out that they were on the move back in February 24th of 2022. And I went to Nick, hey Nick, I just remember this year. And he goes, yeah, Chris, I got the imagery over here. They're loading up the blackjack bombers. They're going to be bombing their children tonight. So that's the way the Russians are celebrating the 1-year anniversary. It's pretty sobering. Okay. And those are real stories. Those are real people, real kids. I worked at NASA. And so I spent some time with the James Webb Space Telescope, right? That's inspiring, for us. That's an amazing thing that Americans can do. That's amazing. The technical complexity of that machine, and the fact that it is actually able to unfold like that over at the Lagrange point or in the moon, and being able to take that. So I last summer went out for a glass of champagne with a guy named Matt Mountain, who's an astronomer and a bit of a philosopher from Scotland. So he's got a little bit brogue to him. And so before it went public with some of the first imagery of the James Webb Space Telescope, he showed me on his phone, like, hey, it's not released yet, but here's some images, coming out. And he goes, and I go, wow, Matt, these are a hell of a lot more inspiring than Maxar imagery is, of death and destruction. And he goes, no, What you're doing is more important. You are literally and figuratively holding up the mirror to the face of evil in our world. And I said, man, can I quote you on that? That's pretty good. So anyway, I thought I'd share that with you. Anyway, I don't know what the legal implications of that are, but there are definitely some real world things to learn from that. All right, I'll stop. Thanks.
Thank you for teeing up also the legal discussion we have. So this is a great order. We have the multidisciplinary expertise on the panel. So please, Professor Nasu, go ahead.
Yes, I'm rather reluctant to intervene after two really fascinating talks. And as one's only a lawyer on the panel, I'm obliged to talk about rather not so exciting the legal aspect of the commercial actors' involvement in armed conflict. And even though I'm a lawyer, I'm not going to talk about the space law because I know many of you are already familiar with a lot of different aspects of the space law. I'm not going to talk about the law of armed conflict. Again, I think many of you have practiced and are familiar with that body of law. What I'm going to talk about instead is the law of neutrality. Certainly, you're all aware of the significant role that the commercial and private actors play in the modern armed conflict. And certainly, since the beginning of the sort of current phase of Russian aggression against Ukraine, there was renewed interest in the body of law of neutrality, how this law of neutrality plays out when the commercial actors or private actors are assisting the conduct of hostilities by one of the belligerent parties. So what I'm going to do is to just give you sort of a very brief sort of basics of neutrality law as a sort of basis for the subsequent discussion of this panel. So I think some of you may have touched on the body of this body of law, particularly since the current phase of the Russian aggression. And some of you may picked up those four principles, which comprises the neutral obligations under international law. First is impartiality, second is abstention, and then third is the duty to prevent, and the fourth one is acquiescence. When the neutral state imposes any major restrictions, they must do so in an impartial manner towards both of the belligerent parties. And the neutral state also has an obligation to abstain from providing assistance, a neutral assistance to help one of the belligerent parties against the other. And also the neutral states has no obligation to prevent their subjects from providing such support. And when they did so, when the neutral subject did provide belligerent or neutral support to one of the parties, then the neutral state must acquiesce in any belligerent action that may be taken against the neutral subjects. So this is a sort of nutshell of this body of law called neutrality law. But what is important is that those obligations are actually qualified in a number of different aspects. And those qualifications matter. So when we talk about the role of commercial actors and the state relationship or potential responsibility over the activities. First qualification is that this neutral obligation primarily applies to neutral territory, territory of the neutral state, or some other sovereign platforms such as warships. Elsewhere, the neutral obligation doesn't arise. The neutral state does not have any obligation to abide by those four principles outside of their territory. That includes the places where they exercise jurisdiction outside of the territory. As for example, the space assets in outer space, under the space treaty, we know that the state can exercise jurisdiction over the space object, but it's not sufficient to say that the state therefore assumes the obligation under the law of neutrality in relation to the activities that may be undertaken by the use of such satellites. The practice is kind of evolving in this field. So even though as it currently stands, what I said is correct, the states may adopt a different position. And one example is Denmark. Denmark has adopted a position that they can claim sovereign status or sovereignty over the state-owned space infrastructure and therefore subject to the law of neutrality. Now, we have to think carefully about what is actually a good idea in terms of our strategic interest with the commercial actors and commercial satellites available. Certainly, if we claim that the neutrality law applies to satellite, that means that the neutral state must assume an obligation to prevent the neutral subjects from providing assistance to one of the belligerent parties. And that obligation may be quite onerous when we talking about various commercial actors providing assistance, and those activities could be attributed to the neutral state. And it doesn't necessarily protect that asset, the space asset, from attack. Whether the space asset is targetable or not is determined under the law of armed conflict, not under the law of neutrality. So if the if the satellite is used in any way to assist one of the belligerent parties with the conduct of hostilities, then it's a legitimate military target, as Professor Blank explained in the morning in a keynote speech. So the law of neutrality doesn't provide a legal protection from potential attacks. Second qualification is that the neutral obligation only applies to governmental activities, the activities that are authorized or undertaken or directed by the government of the neutral state. That means that any activities that may be undertaken by commercial actors is not fall within the ambit of law of neutrality. There is, in fact, traditionally the concept of freedom of private commerce and trade under the law of neutrality. Those commercial actors, they can engage in their trade and commerce in any way they like, without giving any legal implications for the neutral state. Some of you who are familiar with the space law may raise the issue, what about Article 6 of Outer Space Treaty? State may be held responsible for those space activities provided by commercial actors under Article 6. Now, Article 6 of Outer Space Treaty only deals with the responsibility for national activities in outer space, which is about launching the satellite or space objects, or perhaps operation of those, or perhaps the orbiting of the space object. It doesn't extend to any other services that may be provided using those satellites, but to assist activities in the terrestrial domain. So again, I think there's a limitation in terms of how far the new law of neutrality extends to the commercial activities that may be used to aid hostile activities. The third qualification, the law of neutrality only applies to transgression by physical act. So the certainly neutral state has an obligation to prevent belligerent parties from using their own territory as the basis for launch, both for launching hostile acts against the other party, and also they have an obligation to prevent their commercial actors sending weapons and other hardwares. But it doesn't extend to other non-tangible activities. And certainly under the traditional law of neutrality, there is a clear exemption for pre-existing dual-use commercial communication facilities. Now, when the law of neutrality developed, all of the assistance was provided by shipping and land transport. Nowadays, we are talking about providing assistance by sharing a satellite image using the internet, for example, or allowing one of the belligerent parties to use PNT signals and so on. Those are non-tangible assistance. So there's a question about whether this law prohibition under the law of neutrality extends to such non-tangible support provided by commercial actors. So that's a question to be resolved. And finally, it's very important to understand that, yes, the neutral state may be held responsible for some alleged violations of neutral obligations, but that does not necessarily mean that the neutral state is now a co-belligerent party to the armed conflict itself. It's a separate question. The law of neutrality governs the rights and obligations that are attached to the neutral state and their relationship to belligerent parties. Whether they are party to the armed conflict itself is a separate question that is governed by the law of armed conflict. So we have to be careful not to mix them up. On that note, I think I can finish and then open up for subsequent discussion.
Thanks. Before we take any questions from the audience, I guess I want to talk a little bit more about the tension between Article 6 and then this law of neutrality. And what I want to ask is, do you see any extent in your view to the services that a commercial provider can provide to a state in an armed conflict that would implicate neutrality? And so, specifically, how tactical, could a service get? Do you see any limit to, in your view, that where that sort of service would implicate neutrality or through the state responsibility under Article 6?
Yes, I think I can give you sort of an answer as a lawyer about what is the correct understanding of the law as understood by many scholars, for example, or lawyers or legal practitioners. But I think we also have to think about how we want the law to give you an answer. As I said, this body of law of neutrality is pretty much codified before all of these modern technologies came to fruition. It was mainly developed in the 18th, 19th centuries. Most of the rules talking about land transport or the maritime shipments, that's how they were engaging in support activities. But nowadays, we are talking about very different ways of helping the belligerent parties. And even at this stage, we are talking about the use of commercial actors when the United States is outside of the conflict. We're not really involved in the conflict. But our strategic interest may actually be very different if we are engaging in the next conflict and if the commercial actors are actually assisting our adversary with their various technologies. So if we say, well, this kind of provision of commercial services, that should be attributed to the neutral state, and neutral states should be held responsible for the violation of the neutral obligations. I don't know whether we actually want to take that view when we are next involved in an armed conflict, and we are in a position to prohibit such commercial activities and neutral services provided to our adversary. So I think as a lawyer, of course, we are all trying to provide the defensible legal advice to the commanders or the other leadership. But also, this is an area where we need to be strategic about what we actually want to see as the law when it's applied in the future conflict.
Thank you.
I'm going to touch on it from a slightly different angle. There was, in Syria, there was some question of the use of whether or not commercial imagery was used to provide enemy a battle damage assessment on U.S. forces. Okay, and this was a U.S. company on the commercial imaging. There are mechanisms, perhaps not through law, but through regulations, of which the Department of Defense can go to the Department of Commerce and say, look, somebody needs to have a conversation with them or revoke their license here. So those are active. That's an active kind of thing that can go on.
Thanks. Well, are there any questions from anyone in the audience?
Shank, I have a question. Just based on your comment of commerce, do you think that commerce is adequately postured to facilitate that commercial support moving forward, across the agency, across the spectrum, what we're trying to do in space and relations?
The whole caveat of, not the official opinion, blah, blah, blah. But this is recorded for posterity. So I want to make sure I've actually tried to answer the question, because I spent 26 years in government. Okay. And some of that time was oversight over the Office of Space Commerce and Department of NOAA, or NOAA as part of the office, of that. There is, in my time, there was a serious concern on the staffing levels, both actually, I remember for Karen, in working space launch, that's from the FAA Office of Space Transportation, and the staffing levels inadequate as well as the policy. So we have redress, right? We have, as a company, to petition the right to petition our government as done in the Constitution. And we do that, as a Maxar company, we petition the government and say, this is a concern. And sometimes they'll take the form of, going to the courts as well, in terms of whether or not there is a disagreement on what is allowed to be regulated or not. So we have to exercise, our constitutional rights as a company, as well as on the government side, asking those questions. Are you staffed appropriately to accomplish your mission? And with the growth on commercial space, it's a real problem. I'm not gonna sugarcoat that. Did that answer? Okay.
Chris, Tom Ayers, good to see you again. Yeah, it's well. So you made the comment, our satellites have been targeted. Can you expand upon that?
Not in this environment. I really can't. I'm sorry, but this is unclassified and actually this, folks will be listening. So I'd rather not. Both as protecting the company as well as for OPSEC purposes for the other side. So happy to talk on Thursday or back at DC.
I realized I didn't introduce myself the first time. Sergeant Alex Hernitz, Fort Carson Trial Defense. This is for probably everyone, but I think something you said, Dr. Nasu, and when it comes to when you were talking about the different qualifications under the law of neutrality, you pointed out for neutral nations that have the state-owned infrastructure that law of neutrality can apply, talking about LOAC. What I'm curious about is, we talk a lot about Russia and China because those are the biggest actors right now. How do you project the law of neutrality will apply, or how do you think it will need to evolve as more potential governments like Iran or other countries where commercial interests are controlled by the government and there's really no distinction between the two? How do you project the law of neutrality will need to evolve in order to compensate for that as more countries like Iran gain spacefaring capabilities?
It's a very good question. And then, as I said, this body of law is really changing all the time. It's an evolving body of law. And even for the Western states, so there has been sort of a criticisms against drawing this distinction, because all of those commercial actors, when they transport things, we talked about the armed trade regulation, there is a governmental control on what you can actually transport. So in that sense, there is actually an element of governmental involvement. So this traditional notion of commercial freedom and trade is not really a valid claim to maintain in a modern context. So it's just a different degrees of government involvement in those different countries. Now, how we consider that in the future sort of shape of the law of neutrality, that all depends on what the states do. At the moment, we are providing all sorts of support in an environment where the violations of neutrality law are not so important. I think you could, strictly speaking, say that well, some of the exports are actually violations of neutral obligations. Well, that may be so, but for what? Right? Russia is being violating the most fundamental norms of international law. Are they going to bring us to the International Court of Justice? I wouldn't think so. So, the law is shaping all the time, but we also have to think about what is our national strategy? What is our national interest? In the next conflict where we may be involved as one of the belligerent parties, how do we want neutral states and their commercial actors behave? Not to assist the adversary or not to give us a disadvantage in our next conflict. So that's kind of a strategic thinking I think needs to guide our discussion about that particular issue you raised.
I'm going to try to address your question as well as a little bit of what Tom was asking about being targeted. And I actually think the deputy commander of Space Command, John Shaw, said it best at a DC event. He's like, "Is the one thing is about Ukraine is that it is proven that commercial is there for us," meaning DoD. Are we DoD going to be there for them? And so that is an open question of what obligations that the department has to commercial providers in this conflict if they take out a satellite or take out our ground station. And there is no indemnification in our contract, for this. So it's an open question, or other contractual means. So it's an open question of what does protect mean or not.
To say a little bit more on this, I'll stay away from trying to talk about the law of neutrality, but as we should be aware that there are going to be more players in this space from countries other than the US and close NATO allies, or Russia and China, in the same way that, for example, Turkey has become a major supplier of drones. While I'm not too worried about Turkey, say selling drones or space imagery, if they had it, to China if we were in a fight with them, we do often try and limit the availability of armaments to conflicts where we're not really a party. I mean, we would prefer that the Ethiopians and Eritreans not have a lot of weapons. We probably are going to see countries we're pretty friendly with who are willing to sell militarily useful space capabilities into conflicts where we would like to try and tamp things down. And that's, so we're going to have to I think about, what do we think about other, non-adversary third-party countries who are also getting into this space and are willing to sell to actors that we probably would not be willing to sell to.
Dr. Nasu, Major Somler from USSPACECOM Operations Law there. I'm curious if you could address the debate or the diversity of viewpoints on how the adoption of the UN Charter regime affected the law of neutrality. Should an aggressor state like Russia be able to rely on the rights and privileges of a belligerent nation in conducting a unlawful war of aggression against a victim state like Ukraine? Should they be able to rely on that law to prevent other states from assisting Ukraine? Appreciate your thoughts on that.
You may be familiar with the tremendous amount of work in this field done by a Professor Wolf Heinrich von Heineck, someone who I really admire for the depth of research. And he has maintained a position and with which I absolutely agree that there is no such concept as benevolent neutrality. Even under the Charter regime, you are either in a conflict or you're neutral state. There's nothing in between. But even he adopted, kind of modified his position in light of what happened with the clear aggression committed by Russia against Ukraine about, or perhaps this law of neutrality is not really applying, not at least in the form it has been developed in the past to the current conflict. So I think it's a valid view, but also we are aware that there are a number of other states which adopted a very strict neutral position, such as India. So I think as I said, the sort of views are divided, the states' positions are divided. It's in a flux of change and different sort of diverse approaches to the body of neutrality. Again, I think because of that, we need to think strategically how we want this body of law to be shaped, to prepare for the next conflict. What is advantageous in terms of a national interest? I think that's the sort of how the debate should be guided. The Charter itself, I think you can say anything about the UN system. I wrote a paper article with the title of The End of the United Nations. So the title itself suggests how optimistic or pessimistic I am with the current system. But with that, I wouldn't go further than that.
Great. So I'm actually going to go back to Chris, your comment about indemnification and talk about one of my favorite legal topics, which is procurement. And so I would guess, though, to the question of could SpaceX decide that they don't want to do business in Ukraine, or could another company, and I think any company could be in that situation, isn't that in some ways a question of how the procurement has been structured with liability protection? So are they getting PL 8584? Or are they getting, some kind of an agreement in place that protects that upside? And I wonder if you see a big shift following on the situation in Ukraine, where there will be discussions about that procurement question and contractual agreements. It also reminds me of a conversation in another area of space with the Space Force on kind of the idea of a civil air reserve fleet, and whether or not there's some comparison there with a program relative to imaging and intel. It's being talked about more in a cargo program, but is there something to be said here where you would have some kind of an agreement like that? But take that however you'd like.
So 2 questions, on that. Actually, so for Ukraine support operations, that is an active conversation going on at the Pentagon. That we've done our request for clarification and contract modification, for that. So be careful what you wish for, in terms of where we come out on that. And I think this is, having come from, I spent, like I said, 10 years of my life on Capitol Hill, and sometimes there's the legal, answer, and then there's the wrong answer and the right answer. Okay, in terms of trying to resolve something. And a lot of law is about risk management. And then doing the right thing is like, hey, look, what's going on here? Come on, those kind of conversations. On the commercial reserve fleet concept, actually, we initiated that kind of conversation with Space Systems Command, actually, in terms of, hey, you should think of what we're doing, because there are, while we are contracted through the National Reconnaissance Office for foundational, GPS data, and then several other contracts. There are things that are getting, because of timeliness. See, what the DoD users care more about the latency of the data, especially when it comes to the targeting. So we've done various demonstrations with the Army through the Scarlet Dragon exercises. That included Project Maven work, which Project Maven is the joint artificial intelligence center, type work, where we apply algorithms, certain identification algorithms to our imagery, and we can shoot them the lat long faster than it takes to download the imagery, for that. So when we get to tactically relevant, there's an upcharge, right? We're going to have to build, new capabilities in order for us to be able to do that, that timeliness, to get the latency down from, on the order of 20 to 90 minutes to on the order of a couple minutes. Again, depending on the operational use case, you're dealing with, moving targets, tells, that kind of thing. So for us to be, for our imaging systems to be in the fight, and we've done that, and we've said to U.S. Space Command, to the Space Systems Command, is this something that you like to, to build as an upcharge? We can do that kind of work. So does that make sense in terms of answering the contract question? Cool.
This is a question for Professor Nasu. It's regards the special attribution regime in Article 6 of the Outer Space Treaty, acknowledging obviously that it's with respect to questions of state responsibility and doesn't apply to questions of conflict classification. And it encompasses national activities of non-governmental entities, as well as governmental activities. And the reason for that was because the Soviet Union at the time wanted to restrict and exclude non-governmental entities from operating in space completely, whereas the US wanted commercial activity to occur in space. And unhelpfully, national activities isn't defined. But I noticed in your presentation that you said it would encompass things such as launch and deorbiting. And that seems to be quite a narrow application. And I just wanted to ask for clarity if you think it's wider than that, and then if not, how that sits with states potentially not bearing state responsibility for actions of commercial entities. Thank you.
For those of you who do not know, Major Brown contributed a piece, a very well-written piece on the Starlink satellite and the legal implications of targeting Starlink website, the satellites. She did that on our Articles of War blog. We host at the Liber Institute. So anyone who has not visited the site, I would strongly encourage you to take a look at our blog posts, perhaps at least once every week. And there's a variety of really interesting blog posts we publish. And Major Brown's work is one of those highly regarded writings. So the question you posed, I don't know, I think you may have addressed that question in your writing. But yes, I think from my perspective, each body of law or each area of law has its own boundaries. And one of the important things about practicing law is to know your boundaries. And this is one of those areas. In my previous lifetime, I had a client who came to see me to discuss some immigration law issues. But the previous lawyer who advised to the client gave advice on family law matters when the actual real issue was immigration. Now, knowing the boundaries is very important. That client had lost the case because of the previous wrong advice provided. So the question here is, what is the boundary of the space law? And I think, when the space law was adopted, what they had in mind was the launching and an operation and perhaps potentially the orbiting of space objects. I didn't think that they would be talking about any regulation of the use of those satellites in the terrestrial context, and overreaching or sort of expanding the reach of this body of law would simply just would be wrong and would lead to a wrong legal advice. But also it will interfere with operation of other bodies of law that regulate the specific activities. So there are a lot of discussion, for example, if the commercial actors launch, well, I think it's the terrorists, if the terrorists seized control of a commercial satellite and launched a strike against other state, would that be considered as a use of force by the state as part of the national activities in outer space? I think it's just a silly argument. It's just an overextension of what the Article 6 meant to bring to the sort of legal responsibility associated with the operation of the space object. I think that's where my remarks came from.
Ted Richard from Space Operations Command. I'm curious what you think the relationship between the doctrine of countermeasures is as an exception to the law of neutrality, and then if you're aware of any opinion or juris on that topic.
I should remind you, there were two very fascinating talks prior to mine. I think there are a lot of fascinating questions you can ask to those two gentlemen. I hope it's at the 5 o'clock already in the afternoon. It's certainly my body clock, so I'm getting a bit tired. Yeah. So as I said, this body of law of neutrality was developed in a very, very old time when there was no sort of a real legal regime of state responsibility. Even jus ad bellum regime was rather primitive at that time. There was a lot of concerns about avoiding wars, but certainly war itself was not illegal at that time. So we are talking about a very different age when this body of law was developed. So obviously there are a number of different problems when we try to apply this body of law from 18th and 19th century and try to mix up with the 20th century international law, including the law of state responsibility, the prohibition of use of force, right of self-defense. Absolutely, there is a clash, there is a conflict. That's why I have been saying that this body of law needs to be shaped by strategic thinking of how we want this body of law to play a role in governing the future sort of relationship between the belligerent parties and other states that are staying out of the conflict. For example, we talked about the potential violations of law of neutrality by providing support with the weapons and other military hardware. Yes, you could say that's a violation of law of neutrality, but we could also justify it as an exercise of the right of collective self-defense. Well, does it? Does it? We don't know, because no one has ruled on this question about whether the right of collective self-defense or perhaps countermeasures can actually justify the violation of mutual obligation. Certainly, I think it's a feasible and really good legal argument, but we don't know whether that would be accepted. But I think it's up to the states whether that would be the acceptable argument to sort of limit the scope or range of mutual obligations in a future conflict. If everybody thinks, well, yes, I think we should be able to justify it as collective self-defense or countermeasures, or perhaps even collective countermeasures, if you like. Yes, we could shape the law in that way. We have to think about whether it serves our strategic interest in the future conflict.
Good afternoon, Commander Greg Touchton, U.S. Navy. You've given some examples of other countries adopting satellites and other material as critical infrastructure, but it's regulated by a different country. Do you see the progression of this continuing like when a country adopts the US dollar as theirs, completely regulated by the US? Or do you see it more along the lines of, because the reliance on having it maintained as their critical infrastructure, that you're going to see more of a proliferation of either replacements like China throwing up a equivalent Starlink, or multinationals saying, hey, we need this to be reliable so that like GPS, it does it. I mean, GPS can vary in its power because of the US, but we all use that. So given that, do you see a progression or a push within the law or otherwise or policy to have these critical infrastructure aspects be made into something that does not end up being as controlled by one country in its national interests?
I'll take a swing at that one. That wasn't quite a softball, but it's a little faster. Maxar's international defense and intelligence agencies business is growing significantly, primarily due to the threat of China in the Indo-Pacific region. Australia is one of our best customers. Taiwan, Korea, Japan, et cetera, in that theater, and then as well as in the Middle East. So we are providing a service to them that they are then using as part of their defense, similar to the U.S. Department of Defense, and it has to do with a lot of trust involvement. Actually, one of the points made earlier in terms of our offering upgrades to the system for the U.S. Department of Defense is we pointed out to them, oh, by the way, Australia already has this capability that you don't have in theater, because they bought a different package, as a service. So there's a lot of conversations like that. You use some terms there of legally and critical infrastructure that I'm trying to avoid. For us, it is a new business opportunity, and I think for them it is hey, we need this capability as part of our defense and intelligence toolkit.
I'll definitely stay away from any legal aspects. I think my wife still hasn't fully explained the rule against perpetuities to me. But I think you're right that countries that really trust the U.S., like Australia or NATO allies, maybe reasonably comfortable, though I would point even for the Europeans, they spent a lot of money building Galileo because they didn't want to be 100% dependent upon GPS. And you do raise a good question. Well, one question that I would throw back is, as far as I can tell, Russia, probably even the Russian Defense Ministry, is still using Microsoft Windows. I don't know if Microsoft has the ability to, kind of reach out and turn those off. I don't think we have had any expectation that Microsoft would try and prevent adversary country, at least I don't know. I'm not aware of any expectation that they would shut off Windows in adversary countries. Is satellite capability going to be more like Windows? I would suspect that we're going to see countries with capability like China or India who are going to want to develop some of their own communications and imaging capabilities, and that countries who aren't anything beyond a very close U.S. ally are probably going to welcome that.
And we shut off imagery to Russia as well as any Russian actors, and we are informed of anybody who's representing somebody else that is like, no, they're really being backed by Russia. So we work with the U.S. Intelligence community on those kind of things.
Okay, thank you very much to Major Beaulieu and our entire panel here. This was a fascinating discussion. For me as a teacher, I love it because you can take a body of law that, let's say, was largely dormant for a long period of time with some notable exceptions. And our students may wonder why we teach these subjects. And suddenly with the advent of new technologies, new conflicts, new partnerships with the private industry, these questions come roaring back to life in a very significant way. So I really enjoyed that discussion, and I love the passion that you all have for it. It's fantastic. So thank you again very much. And please accept this coin as our token of our appreciation.